If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes, Section 53A, 68.3 at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 4, even though you have found the elements of the crime beyond a reasonable doubt. This will end your deliberations on count 4. 22. Self-defense, defense of others. The defendant has offered evidence in this case that he acted in self-defense and or the defense of others. Self-defense and defense of others are two separate but related defenses. Although the court is instructing you on both defenses under this section, the defendant is entitled to and must be given by you a separate and independent determination as to each defense under each count. After you have considered all the evidence in this case, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. In this case, self-defense and the defense of others applies to all crimes charged in the substitute information under each of the 4 counts, along with the lesser included offenses to each of those crimes at each count. In other words, self-defense and the defense of others applies to all offenses submitted to you for deliberation. The statute defining self-defense, defense of others reads in pertinent part as follows. A person is justified in using reasonable physical force upon another person to defend himself, a third person, from what he reasonably believes to be the use or imminent use of physical force. And he may use such degree of force which he reasonably believes to be necessary for such purpose, except that deadly physical force may not be used unless the actor reasonably believes that such other person is using or about to use deadly physical force or inflicting or about to inflict great bodily harm. The determination of whether a defendant reasonably believes physical force to be necessary to defend himself, someone else, from what he reasonably believes to be the use or imminent use of physical force by another individual is 1. Whether the defendant actually believed that the other person was using or about to use physical force or deadly physical force against him, a third person, and 2, whether a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had those same beliefs. Whether the defendant's belief was reasonable is a question of fact for you to determine based on all the evidence presented. The acts of the other individual, James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4, leading to the defendant's use of defensive physical force, need not be an actual threat or assault. The test is not what the other person actually intended, but what the other person's acts reasonably caused the defendant to believe was the other person's intention. The state's burden. When evidence of self-defense, the defense of others, is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both the elements of the crimes charged and that the defendant did not act in self-defense or defense of others.